The settlement agreement is 41 pages long. I'm signing the last page on a Wednesday afternoon, in a conference room on the 32nd floor of a Manhattan law firm, with a view of the harbor that I'm not looking at. The number on page 38 is $8.4 million. The clause on page 12 says the company admits no wrongdoing. The clause on page 19 says I can never discuss the underlying facts in any forum, public or private, for the rest of my life, except as required by subpoena or court order. My attorney slides the pen across the table. He says, "Are you sure?" I look at the number again. I look at the date at the top of the page. It reads November 14th, 2025. The original filing was in October of 2019. 6 years and 1 month. That is what they paid for. Not the case. The waiting. My name is Robert Mercer. I'm 52 years old, a former senior compliance officer at a regional bank in Charlotte, North Carolina. I was fired on a Friday afternoon in March of 2019, 3 days after I sent a confidential memo to our chief financial officer flagging what I believed to be a deliberate misclassification of consumer loan losses on the second quarter regulatory filing. This tape begins on that Wednesday in November, in that conference room with the pen in my hand. But the story it records started 6 years earlier, in a parking garage in Charlotte, on a cold January morning, when I sat in my car for 19 minutes before I decided to send the memo. Have you ever watched a system protect itself by removing the person who saw the problem? Leave a comment if you have. Tap like if you believe patience is a kind of justice. Follow this channel, because what I did next was not litigation in any way I had ever imagined it. It was just refusing to disappear when they expected me to. What follows is a recording of how a single memo, 11 pages long, took 6 years to become a settlement, and how the people who fired me spent most of those 6 years finding out exactly who I was. It started in 2017. I was 44 when I walked into the regional headquarters of Carolina Trust Bank for the first time as their new senior compliance officer. The building sat on Tryon Street in uptown Charlotte, 14 floors of mirrored glass with a brass letter sign over the revolving doors that read, "Established 1968. The branch network covered 4 states. Total assets were just under $9 billion. We were not a giant by Wall Street standards, but in the Carolinas we were a name people knew. The kind of bank where a small business owner could still get a sit-down meeting with the regional vice president if his account had been there for 20 years. I had spent the previous 16 years at a much larger institution in Atlanta, doing essentially the same job. I took the move for 2 reasons. My wife, Elena, had been offered a position teaching constitutional law at a university outside Charlotte, and she had wanted that job for most of her adult life. The second reason was that I was tired of mega bank compliance, where everything was a checkbox exercise and the real decisions were made 3 floors above me, by people who treated regulators the way you treat traffic cops, polite but never honest. I thought a smaller bank might mean smaller compromises. I was wrong about that, but it took me almost 2 years to understand how wrong. My first day, the chief executive officer met me in the lobby. His name was Walter Crane. He was 61 then, with white hair cut short, and the kind of soft southern accent that makes a man sound like he is doing you a favor when he is, in fact, telling you what to do. He walked me up to the 11th floor himself. He showed me my office, a corner space with 2 windows facing east, and he said, "Robert, we hired you because we believe in doing the right thing. I want you to feel free to come to me with anything. My door is open, always." I believed him for about 18 months. My job was straightforward, on paper. I reviewed regulatory filings before they went out. I oversaw the loan loss reserve methodology. I ran the quarterly compliance committee meetings. I signed off on the call reports that we sent to the Federal Deposit Insurance Corporation and to the Office of the Comptroller of the Currency every 90 days. My signature, in blue ink, on the last page of those reports meant that I had reviewed them and that I believed they accurately reflected the financial condition of the bank. That is what the certification language said, and that is what I believed it meant when I signed it. For the first 6 quarters I was at Carolina Trust. The reports were clean. The numbers were ordinary. The reserves were where they should be. I signed each one without hesitation. I went home each evening to a small house in a quiet neighborhood, and Elena and I had dinner on the back porch when the weather allowed. I want to remember that period clearly, because what happened next happened slowly. The kind of slow that you only notice in retrospect. In the fall of 2018, the bank's consumer lending portfolio began to show stress. Charlotte was growing fast, and Carolina Trust had ridden that growth aggressively. We had financed second mortgages, home equity lines, auto loans, and a portfolio of unsecured personal loans that had ballooned. Default rates began ticking up in September. By November, they were uncomfortable. By December, they were a problem. By the end of the fourth quarter, internal modeling suggested that our loan loss reserves were running roughly $70 million below where prudent accounting would place them. I want to be careful about how I describe what happened next, because I don't want to make it sound dramatic. It wasn't. The most consequential frauds in banking don't come with cigar smoke and whispered conversations in dark rooms. They come with a spreadsheet, a formula change, and a one-line footnote. In early January of 2019, the chief financial officer, a man named Robert Beasley, called me into his office. Robert was 55, a career banker who had been at Carolina Trust for 19 years. He was the kind of man who kept a coffee mug from a charity golf tournament on his desk and a framed photo of his 3 grandchildren on the credenza behind him. He had always been pleasant to me. He had never been quite warm. He closed the door. He sat behind his desk. He did not offer me a chair, so I stood. He said, "Robert, we need to talk about Q2. I said, "We're not closing Q2 for another 3 months, Robert. What about it?" He said, "I want to walk through the reserve methodology with you. There are a couple of assumptions I think we should refine." He slid a single page across the desk. It was a printout of our loan loss reserve formula, with 3 of the input parameters circled in pencil. Next to each circled parameter, in his handwriting, was a small downward arrow and a percentage adjustment. The cumulative effect of the 3 changes, by my mental arithmetic, was to reduce the projected reserve requirement by approximately $64 million. I looked at the page for a long time. Then I looked at him. I said, "Robert, these parameters are calibrated against 5 years of historical loss data. If we change them, we have to disclose the methodology change in the call report. And the change has to be defensible. None of these adjustments are defensible. The default trend over the last 4 quarters runs in the opposite direction." He said, "I'm not changing them. You are. You're the compliance officer. You're going to revisit the methodology and conclude that the historical data is no longer representative of the current credit environment, which it isn't. Charlotte is growing. The economy is strong. Defaults are noisy." I said, "Robert, the default rate has tripled in 9 months." He said, "And then it will revert. That's the nature of consumer credit. You know that. You've been doing this for 2 decades. I said, "We can't do this." He said, "Robert, I am not asking you to do anything illegal. I am asking you to exercise the professional judgment we hired you to exercise. The board has reviewed the projections under various scenarios. They are comfortable with the direction we are taking. Walter is comfortable? I am asking you to be comfortable as well." I said, "I will think about it." He said, "Don't think too long. The CFO sign-off package goes out the week after next." I walked back to my office. I sat at my desk for an hour without opening anything. Then I closed my door, and I started writing. The memo was 11 pages long. I drafted it over 3 evenings, alone in my office after everyone else had gone home, with the door locked and the blinds drawn. I worked from primary documents. I cited the relevant accounting standards. I quoted from the call report certification language. I attached, as an appendix, a comparative analysis showing what the second quarter regulatory filing would look like under the proposed methodology versus the existing one. The difference was a swing of $64 million in the reserve line, which, given our capital ratios, was material under any reasonable interpretation. I sent the memo on a Monday morning in late January. I sent it to Robert Beasley, with a copy to Walter Crane, and a copy to the chair of the audit committee. I marked it confidential. I requested a meeting to discuss the issues. That morning after I sent it, I sat in the parking garage in my car for 19 minutes before I went up to my office. I knew what I had done. I knew what it meant. I knew that the conversation I had just initiated would have an ending I did not control. But I had thought about it for 10 days, and I had concluded that I could not put my signature on the second quarter report under the proposed methodology, and that the only remaining question was whether I would resign before they fired me or after. I chose after. Walter Crane called me to his office on the Thursday of that week. He was not soft that day. He had read the memo. He told me he was disappointed. He told me that I had escalated an internal accounting discussion to a level that did not warrant escalation. He told me that the audit committee had been briefed and that they did not share my concerns. He told me that the bank's external auditors had been consulted and that they had agreed the methodology refinement was appropriate.
What's going on?
I asked which audit partner he had consulted.
How's everyone
He
doing?
gave me a name.
How's life?
I knew that partner.
Amuse yourself.
He was a former senior vice president of Carolina Trust who had left to join the accounting firm 3 years earlier. He was not a person whose independence on this matter could be reasonably presumed. I said that to Walter, in his office, with the door closed. I said it quietly. I said it carefully. But I said it.
Everything's wrong today.
Walter looked at me for a long moment. Then he said, "Robert, I think you should take some time. A week, maybe 2. Think about whether this is the right fit for you." I took the week. I came back on a Monday morning in early March. My access badge had been deactivated. The security guard at the front desk apologized. He said he had been told that morning. He did not know any more than that.
I don't know, really.
I called Robert from the parking lot.
You stressed, Jay?
He did not return the call.
I hate to hear that.
I called Walter. His assistant said he was in meetings all day. I called the head of human resources.
That's what I'm thinking.
She picked up on the second ring.
Question mark.
She told me that my employment had been terminated, effective immediately, for cause. The stated reason was that I had created a hostile working relationship with senior management by escalating professional disagreements in a manner inconsistent with bank policy. There was a severance offer attached to the dismissal. It was the legal minimum. There was a non-disclosure clause that prohibited me from discussing the circumstances of my departure with any third party, including future employers. I did not sign the severance offer. I did not negotiate. I drove home.
These days, I don't know why.
That afternoon, in my kitchen, with the late winter sun coming through the window over the sink, I told Elena what had happened. She was at the counter, slicing an apple. She put down the knife.
I suffer from that.
She listened to the whole story without interrupting.
Back into the groove again.
Then she walked over and put her arms around me, and she said one sentence that I have remembered every day for the 6 years since.
Why do we do it?
She said,
this to ourselves?
"Robert, you do not have to do anything quickly." For the first 90 days, I did almost nothing. I cleaned out the garage.
Man.
I read 3 books I had been meaning to read for a decade. I drove Elena to work in the mornings, the long way, through the neighborhood streets, with the windows down when the weather allowed.
That's fine too.
I learned how to make pasta from scratch, the kind Elena's grandmother had taught her as a girl in Salerno. And on a Sunday evening in May of 2019, I served her a plate of fettuccine I had made entirely by hand. And she said,
So there was
"It's perfect, Robert. Slow down and taste it."
So I had a schedule all lined
I
up.
slowed down. I tasted it.
And
I want to describe this period carefully, because the story that follows is about what patience looks like when the people who wronged you assume it will dissipate.
forward.
It did not dissipate.
Project get moved forward.
What I did quietly, beginning in the second month after my termination, was assemble a file.
It just
The file was not legal.
like
I am not a lawyer.
challenging.
The file was historical. I wrote down on a yellow legal pad in my kitchen every conversation I could remember from the previous 6 months. Dates, locations, what was said, who else was present. I wrote down the names of every internal document I had reviewed during the period in question. I wrote down the methodology change parameters, from memory, with footnotes about where the original dataset lived. I wrote down the audit partner's name and the dates of his prior employment. I did not have copies of the underlying documents. I had not taken anything with me. I had been careful about that, because I had wanted, on my last day, to be able to look at myself and know that I had done nothing improper. The documents themselves were inside the bank's systems, and I no longer had access to those systems, but I knew what they said. And I knew that, if the case went to the right kind of forum, the documents would be produced in discovery. And I knew that my memory of them, written down contemporaneously, would help frame the questions that needed to be asked. In the 4th month, I contacted an attorney. Her name was Margaret Lynn. She had spent the previous 18 years representing whistleblowers in financial services cases. She had a small practice in Washington. I had heard of her because, 8 years earlier, she had represented a friend of a colleague in a case against a brokerage firm in Atlanta, and that case had taken 4 years and had ended in a confidential settlement. Margaret took my call on a Tuesday afternoon. We spoke for 45 minutes. I described what had happened, the memo, the audit partner, the termination. She asked me whether I had documentation. I told her about the legal pad in my kitchen. She did not laugh. She said, "Robert, that is exactly what I needed to hear. Most people forget the dates. The dates are the case." I flew to Washington in May. We met in her office, on the 5th floor of a brownstone 3 blocks from DuPont Circle. She read through the legal pad. She asked me 41 questions. At the end of 3 hours, she put down her pen and said, "Robert, you have a case. It is not a simple case. It is going to take years. Are you prepared for that?" I said, "How many years?" She said, 3, maybe 4. "If they fight it hard, longer. The federal docket in this district runs slow." I said, "Margaret, I have been a compliance officer for 20 years. I have time." She said, "Good. Because what they're going to do is bury you. They're going to try to make this so expensive and so painful that you will settle for less than what the case is worth, just to make it stop. Your job between now and whenever this ends is to not get tired. Can you do that?" I said, "I can do that." I signed the engagement letter that afternoon. The retainer was $35,000. We did not have that money sitting in a checking account. I sold a small piece of inherited property in Georgia. Elena did not ask me to. I told her about it that evening, on the porch, and she said, "Robert, we have always agreed that money is just patience converted into cash. Spend whatever you need." The federal complaint was filed in October of 2019 in the United States District Court for the Western District of North Carolina, 7 months after my termination. It alleged retaliation under the Sarbanes-Oxley Act and the Dodd-Frank Act, both of which protect employees in financial services firms who report suspected accounting violations to senior management or to regulators. The complaint identified Robert Beasley and Walter Crane by name. It identified the audit partner. It described the methodology change in detail. It requested back pay, front pay, emotional distress damages, and punitive damages, in an unspecified amount to be determined at trial. Carolina Trust's response, 60 days later, was a motion to dismiss. The motion ran 112 pages. It argued that I had failed to state a claim, that I had not engaged in protected activity, that my memo had not been a reasonable belief of a securities law violation, that the bank had a legitimate non-retaliatory reason for my termination, and that the complaint failed on standing, statute of limitations, and a half-dozen other procedural grounds. If patience is a kind of justice, hit like before we keep going, because the next 4 years of this story are exactly what Margaret had warned me about, and they are exactly what you will need to hear if you have ever stood where I stood, on a Friday afternoon in March, with a deactivated badge in your hand and a phone that nobody is returning. The motion to dismiss was denied in March of 2020. The judge ruled, in a 15-page order, that I had pleaded a plausible claim and that discovery should proceed. Margaret sent me the order by email on a Tuesday morning. I printed it and read it on the back porch. It was the first piece of good news in 12 months. Discovery began in May of 2020. Discovery in a federal whistleblower case is not what it looks like on television. There are no surprise depositions, no climactic document reveals, no shouting in conference rooms. It is instead an exercise in administrative patience. The defendants produce documents. The plaintiff reviews them. The defendants object to specific requests. The plaintiff files motions to compel. The court issues rulings. The defendants reproduce documents. The plaintiff reviews them again. Months pass between meaningful events. In the first 6 months of discovery, Carolina Trust produced approximately 420,000 documents. I spent most of 2021 sitting in my kitchen, reviewing batches of 200 documents at a time, flagging the ones that were relevant. I learned how to read banking emails the way an archaeologist reads pottery shards, looking for the patterns of avoidance, the language people use when they know something they're pretending not to know.
At least 2 languages.
I found the document I had been looking for in February of 2021.
Okay, I imagine.
It was a draft email from Robert Beasley to Walter Crane, dated December 18, 2018, 3 weeks before my conversation in Robert's office. The email had never been sent. It had been saved to Robert's drafts folder and never deleted. The body of the email contained, in plain language, the rationale for the methodology change. It said, and I quote from memory because I am bound by the settlement agreement not to quote the document directly, that the change was necessary to manage the optics of the Q2 filing in light of the upcoming refinancing discussion with the Federal Home Loan Bank of Atlanta. Optics. Not accounting, not credit risk, optics. I flagged that document. Margaret read it twice. She picked up the phone and called me at home. She said, "Robert, we are going to win this case. It is going to take another 2 or 3 years, but we are going to win it." I said, 2 or 3 more years. She said, "Yes, they will fight harder now. Be ready." The second phase of the litigation lasted from late 2021 to the middle of 2024, almost 3 years. In that time, 18 depositions were taken. I sat through 4 of them as the witness. The first was in March of 2022, in a conference room in downtown Charlotte. It lasted 7 hours. The opposing counsel was a partner at a national law firm, a man named James Holloway, who had a way of asking the same question 14 different ways across the course of a morning, hoping that on the 14th attempt I would answer it differently. I did not. I had spent the previous 9 months preparing. I had reviewed my own memo, line by line, until I could recite paragraphs of it from memory. I had walked through, with Margaret, every conceivable line of attack, every cross-examination tactic, every potential trap. On the 5th hour of that first deposition, Holloway asked me whether I had ever, in the course of my career, signed a regulatory filing that I knew to be inaccurate. I said, "Mr. Holloway, that is the precise question this lawsuit is designed to answer. I refuse to sign one. That is why we are here." He did not ask the question again. The defendants deposed Elena in May of 2022. They wanted to establish that my decision to file the lawsuit had been driven by personal grievance rather than professional duty. Elena was on the stand for 4 hours. She is a constitutional law professor.
Some other places in Queensland where I'm from.
She has spent her career thinking carefully about the relationship between evidence and argument. Holloway did not get from her what he was hoping to get. He asked her, near the end, whether she believed I had been treated fairly by Carolina Trust. She said, "I believe my husband was fired because he refused to sign his name to a document that he had been hired to certify. I believe that the bank's response to his memo, and the speed with which his badge was deactivated, are facts that a jury will be able to evaluate." I am not the jury, Mr. Holloway, but I am a witness to a man who did not sleep well for 8 weeks because he could not decide what he owed to the company that employed him, and what he owed to himself. And I will tell you that he made the harder decision, and I have respected him for it every day since. Holloway thanked her. He did not ask another question. In April of 2023, the defendants filed a motion for summary judgment. The motion ran 231 pages. It argued that, even taking my evidence at face value, no reasonable jury could find that the termination was motivated by my memo, because the bank's stated reason, the alleged hostile working relationship, was an independent and sufficient justification. The motion attached affidavits from 6 current Carolina Trust employees, each of whom stated that I had been a difficult colleague during the relevant period. I read those affidavits in Margaret's office. 2 of the affiants had reported to me directly. The statements were carefully drafted, identical in structure, written in the precise legalese of a defense firm trying to construct a record. They described meetings that, to my recollection, had never happened. They described in one case a confrontation in a hallway that the affiant placed in March of 2018, 6 weeks before I had even started working at the bank. Margaret looked at me across the table. She said, "Robert, we are going to win the summary judgment motion, and then they are going to lose the case at trial, and they know it. This is when they will offer you a real settlement." I said, "When will the summary judgment ruling come down?" She said, "The judge will hold it for a year, maybe more. He has a backlog. That is the federal docket. We wait." In August of 2023, 2 months after the summary judgment briefing closed, Carolina Trust's outside counsel reached out to Margaret with a settlement proposal. The number was $900,000. Margaret laughed when she told me about it. She said, "Robert, they think you are tired." I said, "Tell them I am not." She communicated the rejection. The number went up in November to $1.8 million. We rejected that as well. In February of 2024, they offered $3.2 million, with a confidentiality clause that, in addition to the standard non-disclosure, included a non-disparagement clause that would have prohibited me from speaking, even in private conversation, about the bank or any of its current or former officers, ever, for the rest of my life. Margaret asked me what I wanted to do. I said, "Margaret, I want them to lose. I want a jury to look at Robert Beasley, and to look at Walter Crane, and to look at that draft email about optics, and I want the jury to decide what the case is worth. I am not interested in a number that comes attached to a clause that requires me to pretend none of this happened." She nodded. She said, "Then we keep waiting." The summary judgment ruling came down in July of 2024. The court granted the motion in part, and denied it in part. The retaliation claims under the Sarbanes-Oxley Act were allowed to proceed to trial. The state law claims were dismissed. The judge's order ran 41 pages, and it included a discussion of the December 18th draft email that Margaret read aloud to me over the phone, twice, because I asked her to read it twice. The order described the email as evidence from which a reasonable jury could infer that the methodology change was motivated by considerations other than appropriate accounting judgment, and from which a reasonable jury could further infer that the plaintiff's escalation of those concerns, rather than the asserted personnel-related rationale, was the proximate cause of his termination. In plain English, the judge had written down, in a published court order, that what Robert Beasley had done in his draft email was potentially evidence of a deliberate misrepresentation, and that what Walter Crane had done in firing me was potentially evidence of retaliation under federal law. The order was a public document. It would remain a public document indefinitely in the federal court archives. Any future regulator, any future plaintiff's lawyer, any future journalist who searched the docket for Carolina Trust Bank would find that order at the top of the results. The trial was set for January of 2025. In September of 2024, the bank brought in new counsel. The old firm was replaced. The new firm was a litigation boutique known for trial work. Margaret recognized the lead attorney's name immediately. She said, "Robert, they are getting serious. That firm doesn't do paper. They go to trial. They are preparing to fight this in front of a jury, and they are calculating whether they would rather pay you or whether they would rather take their chances." In October, 2 former Carolina Trust employees came forward voluntarily to Margaret's office. One was a junior analyst on the consumer lending team in 2018. The other was an internal auditor who had left the bank in 2021. Both had read about the case in a regional banking trade publication. Both told Margaret on the record that they had witnessed conversations in late 2018 in which the methodology change had been described, by Robert Beasley directly, as what we need to do to get through the next call report cycle. Both were willing to testify at trial.
To what I'm normally doing.
Margaret wrote to opposing counsel in early November. She did not threaten. She did not posture. She simply attached the witness statements and the order on summary judgment. And she included a single paragraph that read, in essence, "Our client is prepared to go to trial. Our client is also prepared to consider a settlement that reflects the actual value of the claims in light of the evidence now of record. We will be available for a single mediation session in the second week of November. After that, we proceed to trial." The mediation session took place on a Wednesday in November of 2025. It lasted from 8 in the morning until 10 at night. The mediator was a retired federal magistrate judge. The bank's chief executive officer was in the room, not Walter Crane. Walter had retired in June of 2024, 3 months before the new counsel was hired. The new chief executive officer was a woman named Patricia Holcomb, who had been brought in from outside the bank in early 2025. She had inherited my case. She listened, that morning, to a 4-hour presentation from Margaret about the evidence. She asked questions. She did not posture. At the end of the day, she made an offer of $8.4 million, with a confidentiality clause limited to the specific underlying facts of the case, and without a non-disparagement clause. I asked Margaret what she thought. She said, "Robert, this is the number that reflects what you have. It is not the number a jury might give you, but it is the number that ends this, on terms that you can live with, before Christmas." I thought about it for an hour. I called Elena. I told her the offer. I asked her what she thought. She said, "Robert, you do not have to do anything quickly, but you have already done the slow thing, 6 years of it. Take what they are offering, if it is true, and come home." I took the offer. I signed the settlement agreement on the 14th of November, 2025, in a conference room on the 32nd floor of a Manhattan law firm, with the view of the harbor that I was not looking at. The settlement was $8.4 million. After legal fees, after taxes, after the costs of 6 years of litigation, the net to me was approximately $3.1 million. It was not a fortune. It was not enough money to retire on, though Elena and I are nearing the age where, with the savings we had managed to maintain across the 6 years, we will not have to work much longer if we do not want to. What it was a record. The court order on summary judgment, the one that described the December 18th draft email and the reasonable inferences a jury could draw from it, remains a public document. It can be found with a basic search of the federal court database by anyone who looks. Any future regulator examining Carolina Trust Bank will find it. Any future plaintiff in any future case against the bank will find it. Any future hire considering whether to take a senior compliance role at Carolina Trust will find it, if they think to look. Robert Beasley retired in 2023, 6 months before the summary judgment ruling. He did not speak publicly about the case, before or after. As of the most recent public records, he lives in a coastal town in South Carolina, and he is no longer affiliated with the bank. Walter Crane retired in June of 2024, 3 months before the trial counsel was hired. The bank's official press release at the time cited personal reasons and a desire to spend more time with family. I do not know whether either of those reasons was true. I have not spoken to him since the day he told me to take a week to think about whether the bank was the right fit. Carolina Trust Bank itself remains in operation. It is smaller than it was in 2019. In late 2024, the Office of the Comptroller of the Currency issued a consent order regarding the bank's loan loss reserve methodology for the period covering 2018 through 2020. The consent order is also a public document. It required the bank to restate certain prior period financial statements and to implement enhanced governance procedures around its reserve setting process. The bank did not admit wrongdoing. It paid a civil monetary penalty of $41 million. That consent order was issued 9 weeks before I signed the settlement agreement. I do not know whether the order was a factor in the bank's decision to settle. Margaret has her theory. I have mine. Neither of us has discussed it on the record, because we are not required to and because the point is no longer to argue. The point, after 6 years, is to live. As reported in a regional banking trade publication in March of 2025, Carolina Trust Bank also lost 2 of its largest correspondent relationships in the first quarter of that year, citing what the article described as ongoing governance and disclosure concerns at the institution. The article did not mention my lawsuit by name. It did not need to. The court order had been on the federal docket for 9 months by that point. The trade press had been reading it. Some patience is a kind of justice that's easy to miss until you're listening for it. I did not file my lawsuit for the $8.4 million. I would not have known to ask for that number. In October of 2019, when Margaret and I sat in her brownstone office and I signed the engagement letter and I sold the property in Georgia to pay the retainer, I filed it because I had spent 3 months at home, in my kitchen, looking at a yellow legal pad full of dates and conversations. And I had concluded that what had happened to me was not a private grievance. It was a record that, if it remained inside the bank's walls, would protect the people who had constructed it. And if it moved out of the walls, into a courtroom, into a docket, into an order signed by a federal judge, it would have a different life. What I had, when I started, was a memo, 11 pages. I had it because I had written it. What I had at the end was a settlement agreement, 41 pages, and a court order, 15 pages, and a consent order from the Office of the Comptroller of the Currency, 23 pages, and a record of every deposition, every motion, every brief, every ruling, every status conference, every hearing, every transcript in the federal court system, forever. I had a record, 6 years of it. I never raised my voice. I never gave an interview. I never wrote an essay. I never posted on social media about the case. Not once. Not even in the obscurest of forums. Because Margaret told me, in May of 2019, that the people who win these cases are the people who let the docket speak. The docket spoke. It is still speaking. Elena and I drove home from New York the day after I signed. We took the long route, with the windows down even though it was November and cold, because we had not driven a long road together in years. We stopped for coffee at a service plaza in Maryland. We stopped for dinner at a diner in West Virginia. We got home to Charlotte at 3 a.m, and we slept until noon the next day. I do not know what I will do with the rest of my career. I am 52. I have another 15 working years left in me if I want them. I have not yet decided whether I want them. Elena says I should rest first, and then decide. She is, as she has been about everything else in this story, almost certainly correct. I will say this before I close this tape. If you are in the position I was in January of 2019, with a memo half-drafted on your desk and a chief financial officer in the next office who you suspect has already decided what your answer will be, I cannot tell you what to do.
When's that coming out?
I am not allowed to give legal advice. I am not allowed to tell you what your case is worth, because every case is different, and most of them are harder than mine was. But I will tell you what Elena told me, on the back porch in March of 2019, 3 days after my badge was deactivated and my phone calls were not being returned. She said, "Robert, you do not have to do anything quickly."
Release date.
She was right.
17th.
I did not have to.
Wow.
I just had to do it carefully. And I had to keep doing it, slowly, for 6 years. If you've made it this far, you already know what kind of channel this is. Subscribe so the next tape finds you. The stories that come quietly tend to be the ones worth waiting for. This tape ends here.